tremendous event. What a great faculty, a great team, a group of peers. The crew has been awesome. Justin, Dave's group, Jay, David and Charles in the back on camera. I added a last-minute video, and we're going to see if it works here. But these have been 3 special days. I've been so humbled to be a part of this movement that takes place every single year. And this is just my 2nd year with you, but I've heard about some of the previous years and how it's grown because of you, because of the work that this group puts together to bring this quality education to the industry. We're excited about that. I was so blessed by Marlene, who came earlier. I don't know where she's at. She's somewhere. She's a little silent killer. You know, you didn't really expect all of that to come out of her. She's somewhere in the back, but her middle name is Persistence. I'm still looking for her. I see her. I found you. But she's just waving like this. Hi. She's just a little silent killer back there, taking MA plans to town. I love it. She talked about the minimum necessary rule. Last night, I posted that on LinkedIn. If you've not followed me, please follow me on LinkedIn. I've posted that rule and a quick little blurb of how you can use that. I had an interesting question by someone that said, well, have you created these little blurbs that you can use on the phone or in correspondence? Yes, I highly recommend you create a blurb folder so you're not recreating the wheel. We spoke about that in the first session. Please write this down. I advocate for medically appropriate health care for citizens in the state of, and then name your state. I advocate for medically appropriate health care for citizens in the state of, and then just name your state. This week I've shared with you some stories of several patients. Christy, the stage 4 breast cancer patient who we helped, and also Cooper, the 14-month-old baby. These were all pro bono cases that we took in our office to give back to healthcare. And this morning, I'd like to show you one more. Please take a look at this, and I'll come right back to you.
His first surgery was 1 year and 9 days old, and it failed.
Lisa Townsend's son Hudson was born with a rare disease called congenital femoral deficiency. Only 1 in 50,000 are born with a birth defect.
I didn't notice, and the nurses at first didn't notice, but when they took him away to measure him, they came back and told me that his left leg was shorter than his right leg.
Hudson didn't start walking until he was 2.5, using a walker. His first surgery at the age of 1 left him with a broken bone and led to emergency surgery.
He was the youngest to ever have a lengthening surgery.
He had to wait several years before doctors tried again. When he was 10, he had another lengthening surgery, which also failed. After 2 unsuccessful surgeries and doctors suggesting amputation, Lisa was losing hope until she heard about a renowned specialist in Florida, Dr. Dror Paley.
I gathered up enough money, all I could, to get us to a consultation to see him. Sorry.
Dr. Paley said Hudson was a perfect candidate for lengthening surgery, but since he was insured through the state of California, getting insurance to approve the procedure in another state was a months-long battle. Lisa says she couldn't have done it without the help from advocacy group ERN Enterprises, who took her case pro bono to fight the state and won. Dr. Paley performed surgery on Hudson when he was 13 and did another a year later.
It's like a machine they put on here, and it just slowly turns the bone, but you don't feel it, and it pulls 0.25 millimeters each time.
17-year-old Hudson says he hasn't let his condition stop him from anything he's wanted to do.
As a kid growing up, I played baseball with all my friends. High school, I played water polo and swam.
He also likes to golf and says he wants to go to college at Boise State.
They'll say it wasn't that bad.
No.
Lisa says she hopes her story can help other families in similar situations.
Just be your own advocate. Don't take no for an answer.
Hudson has another surgery scheduled for July, which likely won't be his last. Now, Lisa and Hudson have to go to Florida and stay there for an extended period of time, so they're trying to raise money to keep up with expenses back home. There's a golf tournament to help with that on Monday, and there's also a donation page. We'll get links to that on our website, ktla.com. I'm Casey Montoya. Back to you.
Great quote by Eleanor Roosevelt. She writes this: "Never let anyone tell you no that doesn't have the power to say yes." And these are the faces of healthcare. the stories that we've talked about. And you'll never truly understand your impact on healthcare until you begin to see each of your patients as not just a patient number, a patient ID, or a dollar amount, but as a human story. We've shared this week about what to do when payers don't listen, the power of the word no when plans make excessive or improper requests for medical records. This morning, I want to talk to you about you before me. Will you write that down? You before me. People like myself and Day and other individuals in this room understand the power of one. One can take a stand. One can mobilize an army. One can change a healthcare system, initiate a new culture, a new process, and make small tweaks that spark mass transformation. We started a You Before Me movement at our office recently, and that simply means putting people first. Their needs, their dreams, their goals, their growth first. To inspire with purpose. Lego has a purpose to inspire and develop builders of tomorrow, and it has nothing to do with profits or scaling, yet it energizes people to come and show up at work every single day. We asked yesterday, what's your why in healthcare? What's your purpose? It talks about that You Before Me movement speaks of a selflessness, a service that we owe to the industry because, write this down, we have strength to serve. And so we've challenged provider members to join this movement, You Before Me, and identify their commitment to the movement. Here's the commitment that we've made. We will see people and not just spreadsheets and leaderboards. We will be presence and not title driven. We will create a culture of inclusive leadership where the best ideas, not just the best titles or hierarchy, wins. We will inspire people to continuously improve processes in the hospital system. We will see the individual's strengths and successes that they bring to the table and make sure we have the right people in the right seats to reach our goals, to impact our vision, to change and transform human lives. And we will inspire people to be better than us. Please write this down. You cannot be a success unless you have a successor. You will leave one day, and the healthcare delivery system in your hands, in your hospital, in your city, it's in your possession only for a season. And how you influence it, how you navigate, how you fight, how you appeal, how you defend the rights and causes of another. We get to leave that to the next generation, our children, our grandchildren, those that come up and learn underneath us. In other words, we must build not individually, but generationally. When we die, people must know that we lived. And so we're raising up an army of advocates with great passion, not just passion though, but great conviction. Write that word conviction down, because a 4 or 6 year degree will give you information, but it will not give you conviction. Conviction is powerful. It is profound. It is knowing with every fiber in your body that this is what I was called to do. And so we jump in today on issues, and we had a few things that came at our table talk today before I jump into this that I'd like to just share. We had a question of the notice of disagreement process. Tammy had a great question of, hey, how would the patient be affected if we were imposing upon the plan to assume care of the patient in a concurrent denial? And one of the things I shared with them at the table, and I'll share it with you as well, is Medicare laws and regulations were enacted for beneficiary good, not you, not the plan, but for the beneficiary's good, to preserve continuity of care for the beneficiary And specifically, Section 42 CFR 422.113C2 states, if the plan does not pre-approve, not issue a tracking or reference number, but does not pre-approve post-stabilization care services within 1 hour, or they cannot be contacted, or you cannot reach an agreement with them, you can continue the care of the patient until one of the criteria under 422.113C3 are met. And now we understand that's not a standoff. We aren't holding the patient hostage, right? But we understand that those criteria in C3 are simply this. If you've not pre-approved it, you can assume care here, assume care via transfer, rethink your denial, and agree and give us a pre-approval for the patient to remain here while we continue care for this individual beneficiary. And if it gets to the end of discharge and the patient, we've not heard from you, you're financially responsible for the entire state. So when we ask the MA plans for a notice of intent to transfer upon concurrent denial, we are telling them, we disagree. We will continue to treat the patient to preserve continuity of care until you make a decision to transfer or agree and give us an authorization. There was a question of workflow issues. I was at a hospital some weeks or some months ago, rather, and the director of case management said, listen, I love the concept of the medical records refusing those. Here's my issue. When it's denied concurrently, we bill, wait for the denial, and then the back end, our business office, gets the medical record, and they submit that to the plan. Now, I know you stated that we shouldn't be doing that because there is an authorization or is a deemed approval if they fail to respond in a certain time frame. But my CFO will have a fit if I make a decision to change anything. And so he basically said, what can I do? I said, listen, give them the medical record, but give them a fax cover sheet that states something like this. In response to your request for medical records, attached are the requested records. However, please be advised, on January 15th, we called you. You failed to respond within 1 hour. The patient was discharged on January 20th with no response from you, no attempt to assume care for the patient, deeming you financially responsible up until discharge. We don't anticipate any problem. However, the medical records are here for you to determine how to pay this claim and to serve notice that you are preempted from conducting any retrospective medical reviews. So we still gave the medical records, but with the disclaimer. Does that make sense? You can create something very, very similar. Now, because Marlene did such a phenomenal job, I'm going to skip this part of the presentation because I want to jump right into the denial or the process for filing complaints with CMS. We'll start there. Write this down. The CMS Regional Office Account Management Standard Operating Procedure, the AMSOP 3.0, Section 5.2. Now, you can write a Freedom of Information Act request under 5 U.S.C. Section 552 and request this document. I could not give it to you because at the very bottom of this CMS document, it states that I cannot disperse or disseminate this to the public without any authorization from CMS. And it said something about we can punish you to the extent of the law, whatever the case might be. So I'm not giving you that, but I'm showing you what you can obtain in the Freedom of Information Act. This is simply what the account managers follow when you file a complaint. So when you file a complaint with the CMS regional office, you want to find the CMS region office that covers your state. And then you want to determine who the administrator is for that CMS regional office. And then within that CMS office, they will have AMs or account managers who will be responsible for each plan. So every time you see the word AM, you'll know what that is. Here it simply states that every complaint that's submitted goes into something called the complaint tracking module. the CTM. Regardless of who receives the complaint, they must be recorded there. Notice complaints can be received by CMS through a variety of sources, including 1-800-MEDICARE and CMS regional offices, which is what I'll talk to you about today. That SOP adds this later on. Here are the reasons why you can file a complaint with CMS, making sure that you're following all the other time frames. 60 days to appeal. If it's upheld and it goes to Maximus, 60 days to request an ALJ. But while you do all of that, you could follow this process to file a complaint with the CMS regional office. Notice the complaints are recorded in the CTM for trending and aggregation, and it might include claim payment timeliness, unpaid claims, claims inappropriately denied, appeals of claims payment denials, or incorrectly paid claims. Here are some of the things the AM can do in the standard operating procedure. If they felt that the MA plan's actions do not adhere to CMS rules, they can request the plan's policies and procedures to assess whether these documents adhere to CMS regulations, but also, if they do adhere, to assess if their conduct is inconsistent with the document. They'll look for things like that. Later on in the SOP, they also want to make sure that if you're using this process, you're following other procedures that have time frames, that protect your appeal and hearing rights that we talked about earlier. Here's an email that was sent to us from a CMS regional administrator when they established a process for us to follow. And I just want to show you, I have to go over to my slide here because I'll get lost looking at this thing on this in front of me. But they were simply sharing with us here, hey, by the way, you may be a non-contracted provider and CMS doesn't intervene between you and or between two parties in a contract that they are not a party to. So often if you are, if you are contracted rather, they will state we will not get involved. We're not a party to your contract. However, please write this down. Under 42 CFR 422.504, they are a party to the contract with the MA plan. And when the MA plan fails to adhere to CMS regulations, they cannot contract out of those obligations by contracting with you. They have an obligation to follow them. And so what we've done is we've put together a packet. We have gotten information from this particular administrator of how to submit these complaints. And what she has shown us here on your screen that you see is the type of complaints you can file. And I won't go through all of these, but very below, she talks about an appeal complaint, which could be a denial of a specific line item within a claim or failure to notify you of an appeal process. It could be a failure to respond within 60 minutes, failure to act on that appeal appropriately. And then below that, she states you can also file with CMS claims payment disputes. What are those? That's your dispute over the amount that the MA plan paid on a claim, including their decisions to downgrade to a claim to a lower level of care or a DRG. So if you're non-contracted, we know there's a process to forward claims to the IRE. According to Medicare, CMS, if it's a DRG downgrade, those don't go to the IRE. We thought they did. They want to see those directly in this complaint form that I'm showing you here. Here's the CMS region office map. Find your state, pick your region. When you find your state, you'll see your region number. You want to then, if you have a computer, Google Region 9 Administrator, Region 6 Administrator, Region 10 Administrator. Here's a copy of the complaint form that they'll give you. And just for the purposes of time, I'll show you quickly what their position is. So we fought for 20 years for CMS to get involved when there's a contracted provider dispute to some extent, because they wouldn't touch things. Notice on this form that I gave you, it does state, if you look here, it does state on number 1.11 if you are contracted or non-contracted. We fought to get that on that complaint form. Then, of course, we look to the SOP as well. The SOP under Section 5.3.2 states that right in the middle of that, it is CMS's policy that the execution of a contract between an account and provider is between those parties, and CMS will not intervene unless it can be proven beneficiary access to care is being impacted. If a contracted provider contacts an account manager directly, the AM may submit a request to the MA plan to investigate the complaint and to report back to the AM with the resolution. So they will get involved if you are contracted. As I close, I'll show you this case study, and I'll try to see if I can get through some of it just before I let the attorneys come up and speak. But we filed this complaint. Notice the provider member was a contracted provider under Section 1.11. We filed the complaint because, let me go back to that, under brief summary of complaint, patient arrived at the ER, him attempted to make notification to Molina Sr. of possible inpatient admission. Molina failed to respond within 1 hour, as allotted per the section that we talked about earlier. Patient was admitted due to no response. When we wrote this, we got an email back from one of the doctors who quoted our complaint reason, listed the complaint number, talked about the medical record, and basically stated, per the provider appeal cover sheet, the hospital did not file a medical necessity complaint. Therefore, Molina concludes the facility does not dispute medical necessity regarding these 1 hour regulations and allegations that we didn't respond within 1 hour. The medical records submitted by the provider do not support that allegation. The medical records do not show any evidence of attempted communication between him and Molina prior to the member being admitted. It's very important that we understand that. We want to make sure we're making attempts before the patient is admitted. We then, a non-clinician at our office wrote this letter to them, and in short, she basically stated, we respectfully dispute your response. Upon stabilization, HIMIT faxed 4 requests for inpatient authorization for post-stabilization to both the plan and the capitated provider, and on 3/29/16, they both issued tracking numbers. At no time did either entity authorize services within 1 hour. The tracking number constitutes that contact was made even if it's not an authorization. At no time did either entity request a transfer of the patient. We then quoted some law after that, and then the attorney took a shot at Molina. And the attorney simply said this in his response to Little Rose, who's a non-clinician, non-attorney. Listen, per 113 post-stabilization services, we don't believe an inpatient admission was necessary to maintain or improve the enrollee's medical condition. In other words, they believe the patient could have been seen on an observation basis, not inpatient. We disagreed. We were fighting for inpatient in this. Later on, they said 1 hour is hardly enough time to receive a fax, perform a competent clinical review, and respond to the hospital. If failure to respond to that hospital meant the hospital's determination was automatically correct, it would lead to abuse. So we disagreed, obviously, and you'll find that little Rose came back in and she wrote this to the attorney, the big bad attorney, and she simply wrote, "Our position is clear. The 1 hour time frame is to benefit the patient, not you." She continued to quote some law there in that particular letter. Then after that, here's the response by the chief medical officer, who simply writes to us at this point, "Hey, we've read the medical records and we've decided to overturn this case." And he gives us all the medical jargon as to why he's going to overturn the case. But he already had the ability to do that over and over and over again and failed to do so. Why is he now stating he's approving the stay for medical necessity? Because he did not want to prove, or did not want to admit, that they failed to respond within 1 hour of the request for an authorization. In closing, you are the hope and the giant killer that healthcare needs. You are the giant slayer that your hospital or health system has been waiting for. Patients need your voice. And every time you speak for those who cannot speak for themselves, every time you advocate for medically appropriate health care, pursuant to Wickline versus State, you make a bold declaration, you before me, and you fight for those that cannot fight for themselves. Thank you. Have a great rest of the day.